and as well as the members of the public in their various platforms. We resuming today. We met on Wednesday, and we paused for the day yesterday in order to sort out what I regard should be the last hurdles that we had to attend to, and therefore to have a proper start, it's going to be important that to help us in that regard in terms of where we paused. I'm going to invite a representative of the State Attorney's Office, Mr. Isaac Chawe, to get onto the platform. There are a few matters that are important that they be put on record, and he will be helping us to briefly do that on behalf of the State Attorney's Office. Mr. Chawe, are you able to hear me? Are you on the platform?
Good morning, Chairperson. I am able to hear you. I hope I'm audible enough. Thank you.
Okay, I can hear you. It is a bit faint. You're a bit far. Whether you're far from the mic, I can't hear you properly inside here. Can you just reposition so that maybe increase part of your volume? It's important that we hear you.
Yes, Chairperson, I will try. I'm using a very small gadget, but I hope I will be audible. Thank you so much.
That's much better. That's much better. Am I pronouncing your surname properly? Is it Chawe or Chawe?
The first one, Chawe.
Chawe.
Chawe, yes, Chairperson. Thank you so much.
No, thank you, because I could easily have confused it with my clan name, which is Chawe. So excuse me when I give my clan name.
You'll be forgiven for that, Chairperson.
Thank you. Please go ahead. I want to invite you to share what you need to share with us on behalf of the State Attorney's Office. Over to you.
Thank you, Chairperson, and good morning also to the honorable members of the committee. Chairperson, I'm not sure whether should I remain not visible, or is it fine if I were to proceed as it is?
I would request that so that we know who we're talking to, at least so that you can show up, pitch up, and if there's a network problem, you can then switch off so that we know we're speaking to you. As I'm doing, you can see me. Thank you.
Thank you, Chairperson. I'm sorry that there is a bit of darkness where I'm seated, but I hopefully hope that members and other members of the public can see me. Chairperson, maybe let me start here. That I have to explain my status first, where I stand as an attorney from the Office of the State Attorney Pretoria. I am from the State Attorney's Pretoria, and I'm one of the attorneys there. From the onset of this matter, Chairperson and honorable members, I have been instructed by the Office of the Public Protector South Africa to be the attorney of record for Advocate Mkhwebane. And the start of my appointment as such, it started first where I had to be the instructing attorney in order for me to facilitate the appointment of a private attorney who was supposed to have been briefed in the matter. And in fact, the attorney, HM Chani attorneys were appointed in the matter. But due to the developments in the matter, it happened then that HM Chani attorneys were then debriefed from the matter, which then automatically, by default, if I may use the word, then the state attorney became the attorney of record for the Public Protector Advocate Mkhwebane. And fast forward then, Chairperson and members of the committee, it happened then that there were then issues that I needed to proceed and appoint counsel in the matter. As matters stand, I have received numerous, should I say, maybe a communication from my client, being the Office of the Public Protector SA, and also communication from Advocate Busisiwe Mkhwebane, where she raised sharply the issue of my appointment and the state attorneys representing her as the attorney of record. There is at this stage, Chairperson and honorable members, that my status as the attorney of record, so if I refer to myself, I simultaneously also refer to the State Attorney Pretoria or the State Attorney as such, that the State Attorney's status as the legal representative of Advocate Mkhwebane is actually in dispute, in that she has raised in our correspondence and communication that in as far as she is concerned, and by the way the matter has been developing, I cannot, or the state attorney cannot be the attorney of record, as he stated that the state attorney is conflicted in the matter. And therefore, when the state attorney is conflicted, they cannot profess to be acting on her behalf. And the genesis for the conflict of interest, as Advocate Mkhwebane puts it, is that the State Attorney Pretoria, the State Attorney Cape Town, the sister office of ours in Cape Town, has appointed evidence leaders in this particular hearings. And therefore, it can't be that another state attorney on the opposite side can now be acting for her. So that is the basis of her objections to the State Attorney Pretoria being the attorney of record. So in that manner, Chairperson and honorable members, and I will suggest that all members and yourself, Chairperson, the ethical issues which are standing before us, or as the state attorney and myself, is that once a client objects to the representation by an attorney, it then stands that it will be unethical for me to even start to proceed and address this particular committee as an attorney of record for Advocate Mkhwebane. There are other issues which Advocate Mkhwebane has raised in her communication with me. I don't know whether it will be appropriate for me to proceed to then address the committee further on other issues which Advocate Mkhwebane raised with me. But I'll leave then this to the chairperson and honorable members to guide me as to whether can I put on record what other issues Advocate Mkhwebane has raised with me. But I'll leave it there. Thank you so much, Chairperson.
Thank you, Mr. Chowe. Maybe before I ask you to proceed further, just say a quick clarity. So are you now confirming that you would not have briefed counsel, given the status you are tabling here? Can you just respond to that?
Thank you, Chairperson, honorable members. In the course of me and the State Attorney Pretoria being appointed as attorneys of record, we proceeded to issue what we would normally call brief covers to the 3 advocates who have been involved in the matter. We did do that, but just by way of an explanation is that even though such briefs have been issued out, they seem to have issues with their own status, in that because of the fact that the main client does not necessarily recognize or agree to her representation by the state attorney, those briefs are also in dispute, in that an attorney who has not been instructed properly by a client to issue such instructions or briefs to the advocates, those briefs, in a way, they also become null and void. So that is the situation which we are facing as we speak, Chairperson.
Would you also care to just help this committee and the public to just educate us what is the nature of this conflict, so that we are on the same page?
Yes, thank you so much, Chairperson and honorable members of the committee. I've already maybe indicated in passing and in my introduction that, number one, indeed there is a dispute on the representation by the state attorney for Advocate Mkhwebane. That is one issue which is raised, that there is a patent, clear conflict of interest. That's how matters stand. On the other issue, other than the status of the state attorney in the matter, and its inability to appoint counsel on behalf of a client, there are other issues which Advocate Mkhwebane has raised, specifically on the legal funding which has been allocated to her in this matter. The issue is that there is, I will suggest that it's public knowledge, that the Office of the Public Protector South Africa has allocated an amount of 4 million rand to fund the legal representation of Advocate Mkhwebane. The bone of contention out of this particular allocation of funds for legal representation is that Advocate Mkhwebane feels, or she is actually of the view, that there is no clear particularity regarding what these funds, the manner in which they have been allocated, what is that should be excluded or included in the funds. So, like for instance, if I might give an example, Chairperson and honorable members, on the issue of whether, if for whatever reason, this particular allocated amount is exhausted and the matter is still ongoing, the condition that she must now, out of her own funds, proceed to fund the legal representation of Advocate Mkhwebane. And okay, I'm sorry, Chairperson, I thought you were raising some other issues, but then let me proceed.
Yes, go ahead.
One other issue which Advocate Mkhwebane has raised is that it must not be a forgotten issue that the matter of her legal funding is pending before court. So it cannot be that if this matter has not been resolved between the parties, we can for granted then take it that we can still proceed with the matter, even when she's not, can I say, satisfied with the way the conditions are set. So the issue has been raised sharply that this matter is still pending in court, and as a litigant, she is still entitled to prosecute that particular court application to its finality. So in my view, Chairperson and members of the committee, what Advocate Mkhwebane is articulating is that if for whatever reason the issue of legal funding cannot be resolved out of court, if I may use my own words, then the court will have to be given opportunity to listen to the parties and articulate their representation in court regarding this issue. That is one other issue, Chairperson. And one other issue which doesn't have much to do with legal representation, but has much to do with the proceedings and the committee as such, is that Advocate Mkhwebane has raised that there is, as we speak, a matter which needs to be dealt with the constitution of the committee itself, that the chairperson of the committee has to recuse himself, and if that might not maybe be reached, then the matter cannot proceed. And unfortunately, as I've said, the State Attorney Pretoria and myself, Chairperson and honorable members, I have no mandate to move such an application for the recusal of the chairperson because of my status, which I have indicated in the opening address to you. Therefore, there is another issue which is still going to be brought forward sharply on the issue of the constitution of the current committee, in that the current chairperson, being yourself, honorable chairperson, that you need to be recused from this particular hearings. And in as far as I read Advocate Mkhwebane's letter to me and our discussions in the matter, that is going to be a matter which is going to take priority whenever this particular committee starts its hearings. I know, Honorable Chairperson and honorable members, that the registrar, I almost say the registrar, but I should say that the secretariat of the committee had invited me to obtain dates from the advocates on when will they be available to at least appear before the committee. That I also could not do because of the problematic nature of my status, or the status of the State Attorney Pretoria in the matter. So even if I were to contact the advocates, who I must say to the committee and honorable members, I had not received any animosity or any negativity with my communication with the advocates in this matter. We have been cordial all the time. The unfortunate part is that due to the issues of the legal funding and other matters discussed, I'm unable to properly and ethically take any kind of assurances of dates and their availability on the further hearings of the committee. Chairperson, I hope I have covered all grounds which you may have needed me to do. But if there are any other outstanding issues, Chairperson and honorable members of the committee, I will attempt to my utter best to attend to those. Thank you so much.
Thank you, Mr. Chowe. Maybe two more issues to just raise as clarity before I pause with you. So you are indicating that as a result of this objection by the PP, the hands of the state attorney are tied. Am I getting you right?
100%, Chairperson, that is indeed so.
Am I also understanding you correct to say that your client's position is that already the 4 million is not enough before we even resume for the 22 days that are set for this committee?
Yes, Chairperson. Can I just make, although it's just a technical issue, for all intents and purposes, I'm still the attorney of record for the Public Protector South Africa, meaning the mother body, if I may say so. I still have instruction for them. But in as far as Advocate Mkhwebane is, who is also now the actual client, supposed to be actual client, that is indeed so. The confirmation is that as it is, that the amount allocated, there is no clarification as to whether it's not enough or not. But the issue is
you are muted. You are muted.
Sorry.
You are muted. You are saying the issue is?
The issue regarding the 4 million rand, I'm unable to say that Advocate Mkhwebane says it's inadequate. It might be that it might appear to be inadequate in her maybe view, but what is problematic with the allocation of the funds seems to be the conditions which are attached to it, specifically that she will have to burn out of her pocket any amount beyond and above the 4 million. So I do not have instructions to say the 4 million, it's not enough. The issue is that what if it gets exhausted and then she will have to burn this out of her pocket? That is the bone of contention, Chairperson.
Thank you. Perhaps my last point is my understanding correct that also the 4 million or whatever fund is also not in your mandate to determine? You are muted. You are muted.
Thank you, Chairperson. I think I must get used to these gadgets. Yes, it is indeed so. Oh, yes, I'll leave it unmuted. Thank you so much, Chairperson. It is indeed so, Chairperson, that the State Attorney's office or myself, as the member of the State Attorney, we have no, I don't know how to put it, we have no mandate to determine the fees which needs to be allocated, whether adequate or inadequate, in as far as this particular hearings.
Thank you. Thank you, Mr. Chue. Maybe before I go to the next point, the next step, can I, whilst you're on the platform, Mr. Chue, if to just check if any members have any particular clarity or question that they would want to pose to you. I will allow that if any member wants to ask some clarity or question to Mr. Isaac Chue. Honorable Mulder.
Chairperson, if I may ask the State Attorney, do I understand it correctly then that the Public Protector is declining these services that the State Attorney's office is prepared to provide?
You got that, Mr. Chue? Go ahead.
Dr. Mulder, thank you so much, Honorable Chairperson. Dr. Mulder, it's indeed so that the Public Protector is declining to be represented by the State Attorney Pretoria or any other State Attorney for that matter due to the issue of conflict of interest.
Thank you. Any follow-up, Honorable Mulder?
No, thank you, Chairperson. Thank you.
Thank you. Honorable Nkosi.
Thank you, Chairperson, and good morning to Mr. Chue and all in the meeting. As a follow-up question on Dr. Mulder's question, did she indicate, or this way, did the Public Protector SA indicate what alternative would there be? One, or did the Public Protector indicate what alternative if she declines this legal representation?
Thank you, Honorable Nkosi. Good morning, Honorable Nkosi. in as far as Advocate Mkhwebane herself, she has indicated that she's open to accepting legal representation from any panel of attorneys which are on the database of the Public Protector South Africa. So she is not refusing to be represented as long as that representation, it's not the state attorney, but she is amenable to have representation from attorneys who are on the database of the Public Protector South Africa. So in as far as the funds and whether they may be increased or decreased or what other situations will take place on that, I do not have instructions from the Office of the Public Protector South Africa.
Thank you. Honorable Nkosi, follow up.
No, Chairperson, the question was whether the PPSA has indicated an alternative if she does not accept.
Oh, okay. My apologies, Honorable Nkosi. I might misunderstood your question. To this far, there has not been instructions on the alternative, Honorable Nkosi. That will be the short answer.
Thank you.
Thanks, Chair.
Honorable Siabi. Thank you, Honorable Nkosi. Honorable Siabi.
Thank you, Chair, and good morning to the Chairperson and all members on the platform. My question, which will sound like a follow-up also, it's in your experience, Advocate Chowe, if this kind of a thing happens, how do we move forward? Because I didn't hear, I hear that you are saying ethically there's a dispute. How do we move forward in your experience as Advocate Chowe or as the State Attorney's Office? How do you resolve such matters so that we have a way forward? Thank you, Chair.
Thank you, Honorable Siabi. Over to you, Mr. Chue.
Good morning, Honorable Siabi. I hope then my reaction to this particular follow-up, Chairperson and Honorable Siabi, it will be my own views and not necessarily the instructions of any of the clients or perceived clients of mine. But in my experience is that an issue like this, number one, I'm aware that there is a pending litigation in the matter. So once there's a pending litigation in the matter, one will have to, depending on what should happen, that the pending matter be finalized if it is a stumbling block, with due respect, not necessarily that court application are stumbling blocks, that such applications or court proceedings needs to be finalized. But the first prize for me will be for the parties to sit around some kind of a negotiation and come to a negotiated settlement as to how the issue of funding must take place and in which manner it must take place. It's only when such negotiations or settlement agreements or discussions fail that one will opt for the last option being a court proceedings, because the nature of court proceedings, with due respect, may delay the commencement, but nothing prevents. And on the issue of representation, as an attorney, I understand the ethical boundaries which one needs to move around or within. One may not proceed and represent a client who is totally against such an attorney, especially if there are concerns of patent conflict of interest. Therefore, this particular issue, how to be resolved, depending on the parties in the matter, Advocate Mkhwebane could head back to the Public Protector's South Africa's office and have a mandate, or give them a mandate to them to agree, as she has already indicated that there's a panel of attorneys in that office, that they agree on a particular attorney to be appointed as an attorney of record. And it will depend whether the Public Protector SA will still want the State Attorney Pretoria to be its attorney of record and proceed to appoint, in our legal language, that particular private attorney as our correspondent. So we remain the instructing attorney because we will be acting on behalf of the Public Protector SA. And that private attorney then become our correspondent. But because they are our correspondent, we have no control over what instructions they need to execute for the client, being Advocate Mkhwebane, if it were to happen that way. So the issue of conflict of interest will be removed from the issue. And then the State Attorney Pretoria will just be the acting, just be the instructing attorney, and we can only execute instructions which the Public Protector SA will provide to us. And we will have very minimal say in what our correspondence attorney is doing in as far as representing Advocate Mkhwebane. I'm sorry for a long-winded answer, honorable members. Thank you.
Thank you. Honorable Siabe, any follow-up? Are you fine?
Yeah, as a follow-up, I'm not sure whether it's too much, but I would still ask, in your view, Mr. Chawe, or in the view of the State Attorney's Office, is there a conflict of interest in this context?
Yeah. Honorable Siabi, Honorable Chairperson, this one is a very difficult question because, you know, the issue of conflict in any kind, being in legal representation or any kind of dealings, it actually is a subjective matter, according to me, because the complainant regarding biasness, if I might say so, is the one more suited to articulate her perceive of or her perception on biasness or conflict. So I'm very much constrained to say nay or yea that there is conflict in the matter.
Maybe to just conclude Honorable Siabe's question. So it was to explain that perceived conflict of interest in the context that you have got two different offices here. And with that, do you still consider this as a conflict of interest existing?
Honorable Chairperson and honorable members, maybe let me put myself in a corner here in a way, in that in my experience as an attorney and a senior attorney in the office, it has happened many times where, for instance, I'm going to mention, for instance, two agencies of government. All of you, honorable members and chairperson, you know of the existence of the IPIT, for instance, and the Minister of Police. There are matters where you will find that there are two units of government or institution of government will be having conflicting approaches in matters. And it does happen that the state attorney handles those matters, one in Joburg and one in Pretoria, and we proceed them as such. And we proceed to handle the matter to finality. But I don't want to compare now an institution and a individual who is Advocate Mkhwebane, because she may have a different approach as to how she wants to be represented. And in my view, in the facts which are before you, Chairperson and honorable members, it's that if, for instance, as Advocate Mkhwebane says, there is a patent, she doesn't even say perceived, I must say. She says there is a patent clear conflict of interest. So one will have to give her that opportunity to articulate that particular conflict. Because if I were to say there is no conflict, it will be unfair to her, because I will be standing here now as an arbiter to the facts which I'm not actually entitled or even duty bound to resolve. So that's how I might, with due respect, evade that question, Chairperson.
Evade is a very correct one. I appreciate that. Just before I go to Honorable Maneli, just a quick one in your understanding, because whether you would have raised this issue in a discussion, the fact that there is no legal impediment for this committee to proceed, because there is no interdict preventing it from doing its work.
Chairperson and honorable members, it's so difficult to provide a legal opinion in the matter, because my perception as a legal practitioner, it connotes to a certain extent legal opinions, which I must say, with respect, I have to put a caveat on such. It is correct that in terms of our legal system, if a person doesn't have an interdict, there is nothing preventing a particular issue to proceed, especially if there's no interdict. But I have to pause there and say, through my workings with so many matters, I must raise one issue which I hope I'm going to articulate it correctly. That there is something which sometimes is referred to, I hope I have the right words, constructive contempt of court. I don't know whether there's something like that, but, and this wants to mean, according to what I understand, if there are legal proceedings which are pending and they are so essential to the determination of a right of a person or a particular issue, then the parties must, in one way or another, respect that court process until it's prosecuted to its finality, to be able to determine whether this person or an applicant in that matter needs to be afforded a chance to at least prosecute a matter and get a court order in that matter. So I'm also now standing astride in as far as my views in this, that indeed it's so that if there is no court order, an interdict, one will normally proceed with the matter. But on another issue of, maybe it's my own construction, of a constructive possible contempt of court, it's one if we're to proceed and do something which you know that is before court and that court needs to finalize it, but in any event, you proceed. So in Setswana, we talk about Komamoshate, Chairperson. I don't know how to explain it in English. Thank you so much.
That's fine. I get that. Thank you. I was not really asking you for a legal opinion. I was just checking if you would have considered that issue, because this committee has been there before. We've covered that ground. So it was just for you to help us confirm. Honorable Maneli.
Thank you. Honorable Chair, greetings to members and greetings to Advocate Choi. Chair, other points I think have already been covered by the members who spoke before me. I just wanted to be sure, just for correctness of my notes when we discuss way forward. Before there was this communication from the public protector, you are saying that your interaction, and I want to know if I have captured you well, your interaction with senior counsel, which is the senior counsel of choice by public protector, you describe that interaction as having no negativity, cordial in that sense. If that is so, I just wanted to check, Chair, that was there any sense of agreement? I'm saying prior the communication, which raises ethical issues, conflict of interest, and so on, that there would have not been an issue that senior counsel was not prepared to come on board in terms of your interactions. I'm saying up until this matter would have arisen. I just wanted to check on that, Chair.
Thank you so much, Honorable Bese. You know, I'm afraid I might have lost you in as you articulate the question, but I hope I must just attempt to. I hope I understand you correctly, Honorable Maneli, in that yes, indeed, it's so that even including Advocate Mkhwebane herself, we have a very cordial relationship as far as communications and addressing each other. It's very civil, and there's no such. So, and even when they raise this issue, fortunately, is that I can't say that this is a recent development. Even in her initial communications, when the State Attorney Pretoria was mandated to take the matter, she has always been consistent on her issues about the issue of conflict of interest. However, initially, when we had our communications, there was no objection regarding the state attorney having to be the attorney of record for PPSA or the attorney appointing a correspondent for her, which we did actually, Chani attorneys, HM Chani attorneys. There was no issue at all. The issue, I will suggest, then became very clear when the private attorneys then moved out of the way, and now the state attorney had to take the position of being the actual attorney of record. Then the issues then came to a head that she objected.
Follow up, Honorable Maneli.
Yes, Chair. Maybe the follow-up would indeed. I'm trying to deal with an era, Chair, where this termination would have happened. Whether then there would have been interaction as a way of instructing on the side of the appointment of the SC, whether that would have happened after that period, or necessarily everything else would have collapsed. I'm sure, Chair, this may not be clearer for now, but in reality, one would want to check that there were hurdles before. There were pricing issues. Those would have been matters that are agreed to, right? I'm saying other than this issue of the private now, whether there's been any progress made to the extent that you would come to a determination that senior counsel would have been amenable to participate. And of course, it is now this issue that is raised about ethical issues and conflict of interest, which then brings the discussion to be reopened. That is why I'm asking this question. Thank you.
Okay. Assuming that I understand you correctly, Honorable Maneli, Honorable Chairperson, the state attorney must use the common adage, which is usually used in issues of this nature, that the state attorney is a creature of instructions. So whatever the state attorney has done to date has always been an instruction from the Public Protector South Africa. So we received all our instructions from there. It may be that due to the agency of us attending to this matter and appointing the former attorneys, we may not have had an opportunity to have a detailed genesis of what happened at the time of Advocate Mkhwebane speaking to the PPSA and all that. But all our instructions, we received them from the Public Protector South Africa. So it is difficult for me to say whether if it wasn't for certain issues, this matter would have gone smoothly. I'm very much constrained in as far as any other developments which might have taken place between the Public Protector South Africa and Advocate Mkhwebane. But all of what has developed to this far has always with instruction from the office of the PPSA.
No, I'll leave it there.
Thank you, Honorable Maneli. Honorable Labude, you had your hand up. You still want to get the clarity?
Honorable Chairperson, good morning. And good morning to all on the platform. I wanted to ask the very same question that Honorable Maneli has asked of whether the senior counsel of the PP's choice has refused to work with Mr. Chowe, but I was listening to his response. I'm satisfied. Thank you.
Thank you, Honorable Labude. Maybe just as we wrap it up, so that your colleague, if she has any questions that she wants to ask, Ms. Ibrahim, anything you'd want to pick up before I wrap this up?
Chair, I just wanted to remind members that this possibility of the state attorney during the briefing of council was something that was raised by the PP itself, and I indicated this in the last meeting. In fact, it was done twice in writing, and most recently in the letter of 6th of June, the letter which contained the demands, members will recall. And one of those demands was that the inquiry be postponed until the outstanding issues pertaining to my legal representation are resolved. This includes the recovery of my attorney from his current hospitalization and the briefing of counsel of my choice by my attorneys and or the state attorney, whichever is appropriately mandated by the PPSA. So that was put squarely in written correspondence to the chairperson. In fact, Chair, the PP is on a record in this committee in the period after the 4 million had become available, and she was told to instruct Sianego at that time that she cannot do so, that the PPSA must do so, as the CEO is the accounting officer. And members will recall that there was a tussle of correspondence on that particular issue. The CEO, as I now understand the correspondence between the Solicitor General and the CEO, has now given this instruction on recommendation of the SG in order that costs are saved, and given that Mr. Chani was hospitalized, that the state attorney be briefed for purposes of briefing counsel, so to act as the instructing attorney. My understanding, Chair, is that they play a very limited role. For the purposes of the rules, the PP's expert or legal practitioner of choice, which she was entitled to have, is Advocate Mpofu and his team. And that's been made clear a number of times. And members will recall, in fact, that the attorneys of record, Sianego Inc., played a very limited role during the hearings. It's therefore unclear now on what basis this objection is being raised, Chair, because it's council that do the heavy lifting, as it were, and certainly that is the case in respect of the Cape Town office and the briefing of the evidence leaders. In fact, by and large, all they're doing is facilitating the payment to the evidence leaders. Chair, on this issue of conflict, the test for conflict is one of reasonableness. So what would a reasonable person in the position of the PP believe whether there is a conflict or not. It's not clear to me what this patent conflict is that's being referred to. In the last meeting, I explained about the Chinese wall. I indicated that there certainly are occasions when the state attorney may be acting for more than one organ of state. Mr. Chow has now confirmed that. So it is not as patently clear to me as what is being said apparently by the PP, but she's at liberty to explain that in more detail. So Chair, as things currently stand, I personally cannot see what the impediment is now in appointing counsel so that the process can now move forward. Thank you.
Thank you, Ms. Ibrahim. Any quick reflection on that, Mr. Chua? If you want to have any comment.
Yes, as a matter of fact, Honorable Chairperson and honorable members, my reflection is really limited. As I've indicated, I don't have much to say.
Okay.
Maybe as an attorney on behalf of anybody, because as I say, my status is really disputed. So I don't have much to say about the issue. But I've noted what the honorable member has indicated.
She's our legal advisor. She's not yet an honorable member. That's the person who drive things on our behalf to interact with you guys. So that's why I refer to her as a colleague of yours. Thank you.
Thank you so much.
She speaks like a legal. She speaks like an honorable member.
Excuse you, Mr. Chua. Thank you. This is how we're going to do. I'm now going to recognize. I see a hand of the PP. I'm going to give the PP an opportunity for her to reflect on having listened to this. Thereafter, we're going to take a 15-minute break after listening to the PP. And if I may use Mr. Maneli's terminology, when we come back, I would want to present a way forward proposition. So let me now invite the PP.
Thank you. Good morning, Chairperson, to members of the committee, the members of the public. Mr. Chowe, yes, first time seeing you as well, but we spoke over the phone. I think I need to clarify something, and Mr. Chowe can also add or indicate before he's excused, then I can deal with other issues. In the letter which I wrote to Mr. Chowe, it was very clear that I indicated to him that nobody consulted me when they were terminating the services of my attorney, who were appointed per the PFMA, meaning from the panel of attorneys of the Public Protector South Africa. And I never refused to be represented. Hence, my letter where paragraph 28, it's very clear. I don't know why Ms. Ibrahim is trying to just put some unnecessary confusion to the members and say I said state attorney even in the past. Now they managed to do that, the PPSA. I told them when Sianeho was briefed several times, was my attorney of choice who briefed my counsel of choice. And Sianeho withdrew, or his services actually was terminated because of financial constraints or problems. Now I said, Chane is the attorney I can choose from the list, because taking into consideration that I want the office to continue to comply to PFMA, I don't want them to go outside of that. Hence, I said, Mr. Chane. Now they go ahead and terminate Mr. Chane, and Mr. Chane was appointed through the state attorney. So that arrangement, that's what they decided, that Mr. Chane will be managed by the state attorney. They won't be involved. I never had a problem because the monies come from Public Protector South Africa. Now, PPSA decide to terminate Chane. And state attorney also then write to Chane and terminate Chane. And now I don't have an attorney. So when I wrote that letter, I was still saying, you terminated Chane. If you then, and the letter I wrote to Mr. Chowe, I said, Chane or any other attorney from the list, because now they've deviated the public protector by even approaching the state attorney, because that's a deviation. The state attorney is not members of, they are not on our panel of attorneys. Now I was expecting them to have the decency of contacting me, because they write letters to me or emails and update me that PP, now we are saying to the state attorney, let them proceed. What is your view? We wouldn't be sitting here. They decide, they cancel, they withdraw or terminate a Chane who's in hospital. Now I'm saying to in that paragraph 28, which Fatima is trying to conveniently confuse members and portray as if I said I need. I mean, we're the very same Fatima. You indicated that the SG, Solicitor General, in the previous meeting indicated that there's a conflict. Now you try and trying to advise them that there's no conflict and something like that. The issue now is, can Chowe, let's say Chowe proceed, can Chowe continue to dispute and apply a court for the recusal of the chairperson? Can Chowe, our state attorney, go and litigate against the state attorney? Because you, chairperson, and others are represented by the state attorney. So I was trying to make sure that things are done properly. And if I was listened to and not being taken as if or being accused of delaying, this issue wouldn't have been arisen. So I even proposed in the letter to Mr. Chowe that, okay, if you don't want to use the panel of attorneys and you are deviating, possibly the CEO is deviating with the assistance of DPP, then you can also, there's my private attorney, RMT attorneys, possibly then you can brief those attorneys, and then we can proceed. The main thing, Chairperson, is that the legal profession, which I thought Mr. Chowe was going to indicate, Uguti, how the legal profession operates. There's no letter which ever went to even the chairperson, to any person, which comes directly from Advocate Mpofu, Matlape, or Chabalala. Always the attorney of record is the one who should be communicating the information. So I think, Chairperson, coming back to the issue of today, appearing again before the committee, exactly 1 year since I was illegally suspended by the president, and the Western Cape High Court was very clear that that suspension was biased, was conflicted, and had ulterior motives. And it's 9 months since the Western Cape again said I should be returning back to the office, and because my suspension is illegal. And I then lodged, in fact, the president and the DA, same day, the DA lodged an application to the Constitutional Court as an agent application. It's 7 months now. No outcome as well on that particular matter. So, Mr. Chowe, for your information, there's a Constitutional Court judgment on me being represented by a legal practitioner of my choice, which you spoke about the issue of contempt in a way. And there's an application which is still pending. But anyway, that's that. The application or the complaint has been lodged with the Ethics Committee, where I requested the chairperson to withdraw, in fact, to recuse himself voluntarily. And chairperson, today, I know you said you want me by 1 to write. I don't have an attorney. My attorneys have written a letter to you and indicated that in the legal process, I am entitled to the reasons why you are refusing to recuse yourself. So I'm faced with a situation now where I feel that then there's this persecution from all spheres of government, because I'm trying to exercise my rights here I'm facing the state, which is represented by the state attorney in all the matters where we litigated. Hence, as a public protector, we have a panel of attorneys. And I think it's very fair for the chairperson to even, it's unfair for the chairperson to even expect me to respond by the time which you've allocated. So I have sought legal opinion on my personal, in my personal capacity, hence the letter which has been written to the chairperson about the issue of being given reasons for the voluntary recusal of the chairperson. Therefore, the committee without legal representation will be a direct contempt of court, Mr. Chowe. There's a constitutional court judgment which is very clear on that particular issue, and there's various other cases which we brought before the court about that, and even the recusal of the chairperson on another on other facts and basis. It's before now the Supreme Court of Appeal. So I know that the chairperson would want to rule that I refuse legal representation. So you want to proceed. I never refuse. My letter is very clear. I need an attorney. That's how South Africa operates, unfortunately. And members of the public should know. And I think Fatima is the legal advisor. You should also be fair to members of the public that an attorney must brief counsel. And in this particular issue, indeed, an attorney must brief counsel. And I don't know why is it difficult for us to sit down, state attorney, public protector, we discuss this, we find an amicable way to deal with this particular issue, and then my counsel is properly briefed. But again, chairperson, the issue that I must pay from my pocket on whatever is there, and what's worse, chairperson and members of the public, I told Mr. Chowe, he should have said it. It's just that I didn't send her the letter from Galega, because again, the letter from Galega about the 4 million, and chairperson, I think you read it yourself. It says the 4 million, I was told the 4 million is for my traveling, for my accommodation, for everything. I went there 3 times in Cape Town, hence now I'm appearing virtually. And that 4 million is no longer 4 million if we are using that money to exercise or to do anything which one is supposed to be doing. So I think, chairperson, it's my submission, and I think I'm not declining any attorneys, and the letter is very clear. State attorneys, I said, because they, public protector, decided to involve them. Now they managed to appoint Chane. Why can't they appoint another attorney? But the fact of the matter is, I still want Chane. If they go according to the panel of attorneys, if not, they can get another correspondent, and I've suggested who is that particular panel, which is RMT attorneys. So, chairperson, PPSA, Public Protector South Africa CEO and Deputy Public Protector, unfortunately, are the ones who are causing all this delay and this confusion and this mess, because we should be cordial with each other, sit down and see how we can speedily assist the process. So I think I'll just indicate, chairperson, that the legal representation is a must, unfortunately, for you to proceed with this particular matter.
Thank you, PP. I see your hand, Honorable Maneli. Is that an old hand?
Thank you, Chair. It may be old in the sense that I raised it before the PP spoke. Okay. But you could not see it in that score. However, the matter remains relevant.
All right.
Chair, as you take the break, I think it's important just from a point of consistency. We've had Advocate Joy appearing before us, stated what he has stated. We had an opportunity to interact with him and ask questions on matters we may not be clear about. This last point made by the PP is very important in this consistency I'm talking about. That your appearance before this inquiry is on the basis that there must be legal representation. So every time you give the opportunity to speak, it therefore remains one-sided because you can't engage it without legal representation. So next time when you at least have this opportunity of her appearing before the committee, we should know what the status is. Can we engage the matters that she's putting on the table so that we are even more clearer, because it helps us to go forward. So that's the reason I was raising the hand even before, so that now that it's clear there's no representation, Mr. Advocate Cho is no longer representing because of ethical issues and so on. What will be the basis of proceeding as she appears before this inquiry? Because all what she has said was said before this inquiry. So I'm just saying, Chair, from where I'm sitting, there may be inconsistency there, and I don't want us to be caught in that. Thank you.
Thank you, Honorable Maneli, for registering your points. Just before we take a break, Ms. Ibrahim, any last point you want to raise?
Chairperson, the initial correspondence from the Solicitor General is to the Office of the PPSA, not to us, and it talks about there being a potential of a conflict of interest. But also, Chair, that this matter is fast moving in that there are developments that then inform steps that get taken later on. One of those developments being the fact that Mr. Chan had taken ill until further notice, and the other one being that the fees of counsel had now increased. The use of the state attorney is not done via procurement for purposes of the PFMA. There is no payment that is made to the state attorney's office, which would result in a saving. And this is something that the Solicitor General mentions in his letter to the PPSA when he raises this as a possibility, because this scenario now allows for cost saving, which would arrive at additional days in which the PP then can be represented. So there are efforts being made to try to manage the funding. But I won't speak further on the issue of conflict. I've explained that the legal position is the test of reasonableness. Thank you, Chair.
Thank you, Ms. Ibrahim. We're now going to take a 15-minute break, colleagues, and be back after 15 minutes. Thank you.
Recording stopped.
We've just come out of the tea break. I indicated before the tea break that I would want to make a few and very concrete way forward proposition, borrowing from Honorable Maneli's terminology. Maybe before I make those points, there might be incoherence here and there, but I tried to do that. I think it's important as part of our context to indicate that we are operating, and this would have been very much ventilated in our meeting of Friday, the 2nd of June, as a committee. We are operating within a tightly determined timeline within the 22 days that we have been assigned to complete our work. We have been given 4 million. There is no intention, as we indicated on Friday, to extend those 22 days. There is no intention whatsoever to deplete the 4 million and ask for more money. We're very clear as a committee about that we need to work in such a way that we work within budget. It will be a bonus if we work even less than that 4 million. But there's certainly no intention to go beyond it. We've worked in a very difficult way to get to that point in the first place. And there's just no way that there's another avenue that must be opened up for some possible depletion of that 4 million. I want to start with that and be very clear about that, in line with our discussion as a committee on Friday. We've also been very firm and clear throughout this process about respecting the need for ensuring that there's legal representation of the public protector. We've done everything else to ensure that that happens. And up to today, as I speak, the PP has not been denied any legal representation. Of course, we heard from the representative of the state attorney, Mr. Chowe, and a follow-up made by Honorable Melder on that issue, that there would have been objections, and therefore the assistance intervention of the state attorney declined. So as indicated, therefore, colleagues, in the meeting on Wednesday, we have taken numerous steps and made several interventions to assist the PP in securing legal representation. On Wednesday, I took you through chronologically from the point when we're told, before there was a lack of fund, we're told that the PP legal team has not been paid. Something that was not in the terrain of this inquiry, myself as a chair, went out of my way to ensure that happens, and things started moving. So I would have taken you through step by step all of the kind of attempts and interventions that were made. Unfortunately, we find ourselves in this position that when we take a step forward and we think we have made progress, then there is a setback of sorts. So it's become a DNA of this inquiry of late, since February and March, that we would pick up a new hurdle, we attend to this new hurdle, another hurdle is put in the way of this inquiry continuing. Unfortunately, this committee does not does not have control or direct the budget of the PPSA, and the PP has not been able to move a chosen council on their fees. Remember, we spoke about on Wednesday, as a new hurdle. Once there was an appointment of the senior council together with the juniors, then the next new hurdle was the increase in rates in terms of the fees. And I've indicated at this point, we're constrained by this ring-fenced 4 million to complete the process and to do so in a manner that is fair. So these setbacks have been caused by various factors, and I'm not going to spend time now apportioning blame on anyone, because some of the factors have clearly been due to circumstances beyond anyone's control. Because when somebody is sick, is hospitalized, we can't control those kind of situations. These developments take place in the context of two things. The first is that this committee is bound by the Constitution and the rules of the Assembly to complete its task, which is the consideration of the motion before us in a fair manner, within a reasonable time frame, without delay. Secondly, the PP, and she would have said this herself even today, who is the subject of this inquiry, has been suspended, and she indicated today is a year-long suspension from the 9th of June 2022 up until today. And therefore, when we commenced this process, she was already suspended, and we think that she too has a right to have this matter brought to finality. And so we've got to balance these important issues. If we fail to do so, it will leave her in a position of this matter hanging as a cloud over her, as it were, and it can never be said that such would be fair or right. We're fortunate that we have made important progress during this close to 11 months. It's a lot of work that has been done. We are indebted to the work and the journey that we've really traversed. The PP commenced with her oral testimony, and she covered what Advocate Mpofu said was the most important topics of CR17 and SARS. We commenced with this testimony having the benefit of the PP's written statement, which responds to all these charges and which was her part of the audi she has been afforded since the hearings commenced. In addition, she has been allowed to cross-examine witnesses and call her own witnesses. The purpose of our oral testimony was to amplify this and then allow the evidence leaders and members to put questions to Advocate Mkhwebane as a subject of the inquiry. It is at this point that we seem stuck and not able to move forward because of issues of availability of counsels, amongst others, as we would have dealt with in the morning. In addition, the PP has taken issue with my instructions to the evidence leaders to take the committee through the records on Bosasa, CR17 and SARS matters. She also objects to my proposal to proceed to deal with the inquiry in parts by concluding the evidence on Statement A before we commence with Part B. In addition, she raised concerns about funding and that she won't be in a position to fund this process when the additional 4 million is depleted. I've made my point about that we are not in a business of even depleting that by a cent, that 4 million. Because finances are certainly not in our control. I've also given regard to this, and I propose this as the way we must do things going forward, which might help to alleviate some of these issues and hopefully allow this committee to fulfill its mandate. And therefore, I want to raise the following issues for your attention and for our way forward. That I will direct that members and evidence leaders put in writing all questions they have on any subject matter in relation to the charges in the motion in writing. These questions will be collated, preferably by a topic, and provided to the PP to respond. 2, should the PP wish to respond orally, she will be afforded the opportunity to attend hearings not later than a day after being provided the questions, so that evidence leaders and members can put these questions to her orally, and of course, any questions that may flow from her answers. In turn, a counsel may re-examine her, as it were, to the extent it may be necessary to clarify anything that is arising from these questions. If her preference is to proceed, is to respond in writing, I will allow time and space for her to compile her answers and submit it under oath. Of course, no re-examination, if it is in writing, will be necessary. In the interim, while members and evidence leaders conduct this important exercise of putting their questions, if any, not saying that you must have questions when there might not be a need for any questions, I will allow the PP to submit anything further she wishes to submit in writing, in addition to the statements given to us, which is both part A and B, which may have arisen since we paused the hearings on the 31st of March. These two should be done under oath. Should the PP fail to answer the committee, the committee will have no choice but to make its findings based on the evidence before it, including the PP's statements, part A and B, which were done under oath. Thankfully, much of the evidence before us is already in the form of sworn affidavits, which will assist us in our task. Members will be afforded an opportunity to consider these answers, which, as I say, may be oral or in writing. I will then allow the PP, via her counsel, an opportunity to make a closing statement orally or submit same in writing. I'll ensure that we provide more than one possible date for this to accommodate the availability issues. As we know, in this process, we've always been hit with those kind of issues. The evidence leaders will be expected to do a summation of evidence, and then the laborious work and process of report writing will have to happen once members have deliberated. These deliberations, of course, as I always indicate, we're not doing anything in a smoke-filled room, dark room, will happen transparently in the public. All of our deliberations. And whatever draft report will do, whatever recommendations we make, everybody will be with us as we do that. The process of report drafting will then have to take place, and this report in draft form submitted to members for consideration and adoption. Changes as proposed after such a discussion and agreed to will be made, and any members may submit a minority or contrary view to any findings which will be incorporated into the report. The report in draft form will be shared with the PP for comment, and this, colleagues, will form her additional and last Audi, or final Audi, before a decision on the adoption of the report will be made. To the extent the committee agrees to make changes to that draft report based on whatever that would have received as representations made in that regard. We'll then table the report, and the process will be led by the table, as we say, NA table, as our job would have been done. So if members are in agreement with this proposition as part of the way forward, I will henceforth issue directives to cater for these changes and set out a timeline in detail in which these steps will occur. This will be shared with everyone. Given the time and the cost considerations, practical difficulties with availability, there doesn't seem to be any other option except what we have throughout this process been patient about in doing. And as all of this is happening, there is going to be a concerted effort from this afternoon, based on the earlier discussion, to make sure that all of those issues that were ventilated this morning are fully attended to in terms of the discussion we've had after listening to the representative of the State Attorney's Office, Mr. Chowing. I want to pause there and therefore invite the honorable members. If there are members who wants to make any reflection or comment on this, I am now going to allow for that opportunity. Honorable members. Honorable Nkosi.
Chair, I agree with you in detail. The only thing that I think you have to ensure throughout the process in your detail is that the process should and must be seen to be open, transparent, and reflective of an exercise of our responsibilities in an open and an accessible way. I think that there are elements in both your proposals that cater for that, but I think maybe just give some consideration in nuancing them further so that we are not seen to be doing this work outside of the public eye. Otherwise, I agree with what you're saying, and I move a motion on my behalf that we accept that as a way forward. Thanks, Chair.
Thank you, Honorable Nkosi. Any other member? Honorable Siwela.
Thanks, Chairperson. I just want to second the motion put before us by Honorable Nkosi that we accept your proposal so that we are able to conclude this process. Thank you.
Thank you, Honorable Siwela. Honorable Mailam. Honorable Mailam. Honorable Mailam, are you there or are you muted? Let's keep him. Honorable Gondwe.
Good morning, Chair, and good morning to everybody on the virtual platform. Mine is just to say that I support your proposal on the way forward, and I look forward to us concluding the work that we've started. Thank you very much.
Thank you, Honorable Gondwe. Honorable Mailam, you back? Not yet. Honorable Maneli.
No, thank you, Honorable Chair. In agreeing with your proposal for the way forward, I understand. I think the points covered for me by Honorable Nkosi that at all times it has to be seen to be fair for both sides. That of the PP who appears before this committee to answer to allegations leveled against her, but as well as for the committee to be able to do its work and come to a sense of finality. Now, I'm raising then another point, Chair, which I thought you'd also cover in your summary, because at the time of breaking, I think I've raised the point and I'm raising it because I would still need to know what the status would be in the absence of legal representation as the PP addresses the committee. So that again, we do not get to be accused that as a committee we didn't look at that matter, that we continue to engage with in the absence of such representation. Otherwise, the summary for me, Chair, is quite clear. First option, it's given to the PP to follow the other route, and you are also indicating in the failure of those how the committee should then be able to still fulfill that task and still affording the PP an opportunity to answer. Thank you.
Thank you, Honorable Maneli. Honorable Mailam, are you back?
Yes, Chairperson, thank you. I'm sorry about that. I had a connection problem. Chairperson, while this isn't an ideal situation and it's problematic that we are unable to engage the testimony of Advocate Mkhwebane directly or orally, I do think, given the challenges that we've faced and the hurdles that we have to overcome in getting this matter concluded, that your proposal is very much the only way forward that is going to actually get us out of the quagmire we find ourselves in. So I want to support the idea that we submit the questions in writing and that we then allow Advocate Mkhwebane to respond to those questions and that we deal with it in that manner, because I cannot see this matter being resolved if we continue to delay and wait and go around in circles discussing irrelevant or sideshow issues and not the actual evidence before the committee. Thank you, Chair.
Thank you, Honorable Mailam. Is there any member that I'm leaving out? Let me quickly check on the platform and I will repeat. Is there any member I'm leaving out that I might have missed his or her hand on the virtual platform? No member. Thank you for that. I'm just considering members now. And then I'll come to a member here who participated before while she was walking. Honorable Dlagude. You're not on air, you walk to the bench.
Thank you very much, Honorable Chairperson. Good morning, evidence leaders, public protector and members on the platform. Honorable Chair, indeed, I was walking to the room, but that is due to the fact that I had another meeting, so I was multitasking at the same time. So I want to agree with my colleagues that we support your detailed proposal so that as this committee, we are able to move forward. You remember we discussed at length, I think it was Friday last week and also on Tuesday, we rehashed what we discussed on Friday last week, that we need to conclude the work that evidence has already been led. Submitting those questions, I think, is the best way to do as this committee. Thank you very much, Honorable Chair.
Thank you, Honorable Dlagude. With members, you being the last member on this, I will now recognize, I see the hand. I was going to give you an opportunity, but since you have raised your hand already, I will do that as well. I see the hand of the PP. I now recognize you.
Thank you, Chairperson. Indeed, I'm not the member of Parliament. You've made that very clear and I've heard it. Thank you for giving me the opportunity. Chairperson, I wanted to clarify something with you. I think going forward, I will request that Ms. Ibrahim Fatima should be very honest and when advising members of the committee, because I mean, she should have raised the issue of what the SG said about the conflict from the beginning instead of allowing this matter to be discussed. Chair, I'm willing and able to engage with Public Protector South Africa to allow me to have legal representation of my choice, so that when I respond to those questions, which I should be assisted by legal representation, because I will not answer any question without my legal representation. So I hope that process we will move with speed. And Chairperson, I agree with you. Saving on costs, exactly what I wanted to do. And it's strange that I wonder whether the state attorney, whatever they've done, they will do it for free, because what I know is that state attorney also charges. I wonder why PPSA decided to go brief state attorney instead of briefing Chane directly. So I think those are the issues. But what is critical, Chairperson, is that indeed, whatever you've mentioned now, the process which you are saying you are going to take is not provided for in the directives. And it's an unlawful process, which members, all of them are agreeing to that unlawful process. And fortunately, again, it's what exactly the late Tina Jumat Peterson said, but that will be revealed that this is what you would want to do to circumvent the process. So I'll hear from you, Chairperson, as soon as the Public Protector South Africa has made sure that I have a legal representation, because unfortunately, they are the cause of all this mess with their letter of 1 March 2023, and now the issue of 4 million terminating Chane and everything. So I will proceed, Chairperson, with the process. So, Chairperson, finally, can you, by you saying this, it means you are refusing to voluntarily recuse yourself, because I think that is very important. Yes, and then the second issue is that the issue of this constructive contempt of court, the issue of legal representation, but as well the issue that the matter is now before the SCA of your recusal, but now this is another matter of alleged extortion and corruption. So I just need to hear that information so that I can put it on record.
Thank you, PP. Thank you, PP.
Yes, Chairperson. As I said, yes, I reject the proposal as presented, because anyway, I need to, as it's in violation of the Constitution. Hence, I said now the issue of legal representation. So I hope that issue is catered for. Thank you.
Thank you, PP. I did in my presentation indicated that I did indicate that and that seems to be that now, and I will still put that to confirmation. All the members that would have spoken are in agreement with the proposal for the way forward. I indicated that once that's in place, I will issue the amended directives informed by that. So the point you're raising about directives has already been catered for. So, but also the issue of legal representation, I did indicate that that work is not stopping. It will continue, maybe even with much higher efforts and speed than we have done so far, because I've indicated that this committee has not.
Sorry, Chairperson, you are breaking. I don't know whether it's on my side or it's on your side, but apology for just budging in.
Okay.
The thing is, I don't hear you somewhere here.
No, thank you for that. Can you hear me now?
Yes, Chairperson.
Thank you. So no, I was saying, PP, that the issue of legal representation that's a matter that we were seized with for it to reach that finality as would have started.
And you issue reduces.
Maybe the problem might be now on your side. Please mute. So we have been on this issue of assisting with issue of legal representation, and we're not going to tie on that. We're going to continue doing that. Everything else in relation to that will be attended to. I've made the point about if everybody agrees to this, the directives will be issued to conform with what we're discussing and agreeing to. I am still waiting. By 1 o'clock today, 56 minutes left, as indicated, that I will welcome an application for my recusal and will respond to that on Monday. I will attend to that when that reaches my space. So there should be no issues about that. Just to conclude on this, honorable members, may I ask if there's any member who's raising any objection about this proposed way forward, as indicated, because everybody else would have spoken, is in support with amendments that must be made, which are taken into account. Is there any member? No member, and therefore there's no objection. Honorable Herron?
Chair, it's not an objection, but you read off some instructions. I just want to confirm that we will get those in writing as well, so we are clear about them.
Thank you, Honorable Herron. In fact, not only for members, including for the PP, we are going to send out what I was running through, as I said, in detail, including the timelines and everything else. So you are in order, and that will be done. Thank you, Honorable Herron. Any other member? None. So there is no objection, but I think that's that request.
It's my objection as chairperson. I think I indicated that rejecting the proposal. So I hope anything which will be sent to me will be sent as soon as we know who is my attorney, because if it's sent to me, I won't be able to deal with it, especially the attorney to represent me in this process. And then secondly, the issue of your recusal, which I kindly requested that I've sent a letter through RMT attorneys that I won't be making any application because I don't have attorneys, but then I've put it there in writing. Hence, I requested you to indicate and give reasons why you are not recusing yourself. So that's all I want to put on record. And I'm rejecting the proposal and I don't agree with it. Thank you.
Thank you, PP. The letter we have received today, just 10 or so minutes before 10, will be responded to as a letter. And you seem then to be saying that I must expect no application for recusal by 1 o'clock.
I have no lawyer.
No, you don't have to respond. Thank you. And so I'm just saying that we'll respond to that letter that we received 10 to 10. This I've not read. I've been told that there's a letter. We'll attend to it. And secondly, as I indicated, we'll send this out to the members and to yourself as a subject of this inquiry and somebody who accounts to the National Assembly in terms of your work. I've already attended to the issues of us continuing to address the issue of legal support and so on. Otherwise, your points you have made are noted, PP. With that, colleagues, if there's no other issue, I see there's a clarity sought by evidence leaders. Advocate Bauer.
Yes, sorry, Chair. I don't want to delay the members, but I do want to raise a possible permutation. We haven't had a long time to apply our minds to this approach, it having come up after Wednesday's meeting. And from our side, the members would appreciate that questions in writing is a lot more labor intensive, because you would need, it doesn't have the natural flow of an oral question where you have a follow-up to fill in a lot more precisely. Having said that, and not wanting to be the cause of further delays, the members would also be aware that as evidence leaders, we've been a lot more prepared on the Part A statement than what we are on the Part B statement, because the oral evidence had been led on the Part A statement to do that. And so, mindful of that, we would want to consider that instead of giving all the questions split up as a Part A question with a deadline and a Part B question with a deadline, especially given that the chair has invited the Public Protector to make further submissions in respect of that. I understand that she has not amplified in oral evidence, and that would mean that might facilitate the process. I'm making this because it has a material bearing on us being able to meet any deadlines that is put in to the process, and that there be a mechanism which I wasn't sure you had filtered into it, is that obviously there's going to be some repetition of questions from us and from members, that there be some consideration given that the PP does not face repetitive questions in a filtering way that would then also result in a wastage of resources. In other words, neither the evidence leaders and, most importantly, members must have that in mind when formulating questions in a way that the Secretariat could manage that appropriately. In that way, for the rest, Chair, we would abide by whatever the committee decides.
Thank you, Advocate Bauer. I think those are useful and enriching comments to the implementation, which are aimed at meeting the deadlines, splitting the questions into parts A and B, ensure that there's no repetition in that, but also to be much smarter to understand that it's not an oral interaction. It's a written, so the nature of questions must therefore take note of it. I don't think there should be any problem with it.
And Chair, maybe with me from the committee, we have never regarded ourselves to fill an adversarial role. And should the Public Protector require any assistance in any of this from that, we would from finding, from being able to deal with where any question originates from in the record, we would, be it through us or via the Secretary, probably via the Secretary, there's a record, the evidence leaders would not have, well, we would avail ourselves for that assistance as well.
Thank you. Point taken. Thank you, colleagues. With that, I don't think there's any further point. Thank you for those additional points for us to take into account. You will therefore hear from the chair in this detailed writing that will be sent, and will make it much quicker for everybody to prepare themselves for that, because it will stipulate by when certain things must happen and so on. So as you take leave or a bit of that, the chair and the party will be working and to ensure that you received the necessary information. Thank you very much. The meeting is adjourned.
Everybody.
Thank you, Chairperson.
Recording stopped.